Hi, I'm Steve Dale, and I'm the trustee of the Golden State Pool Trust here. And this is part of our MCLE series that we call the Essentials of Disability Advocacy here. A couple things as we get into this here. This is part of our ongoing series. If you are interested in taking further classes and be noticed when these classes come up, and these would be whether you're a trustee, an attorney, or the general public, or a person with a disability that's just trying to learn a little bit more about our community and our law here. This is a really important topic, and for those of you that have been following this, I originally trained at Disability Rights Education and Defense Fund to do access law and ADA law, the kind of law here that our guest here, Celia, is going to be doing here. This is really important law. Now, for those of you that are watching, the objective isn't necessarily to turn you into access attorneys, although if you want to, we certainly could use more of them. This is really more for issue spotting, but if you're working with persons with disabilities, whether you're a trustee or an attorney or just an advocate for folks with disabilities, it's absolutely important that you understand, our access laws and how they work. A little bit about Celia, and there's a lot to be said here, is Celia McGinnis, who's somebody we've known each other for quite a long time. We can't remember how long here, but it's been quite a long time here. She's a disability rights lawyer, founding partner of Derby, McGinnis, and Goldsmith, LLP, here in Oakland area. But you practice, all over the Bay Area, all over the state, right? Okay. And in each case that she takes, she tries to confirm and expand the scope of the ADA and fair housing laws. Her published cases include Tamara versus El Camino Hospital, the first case in the nation to rule that service dogs may not be excluded from a locked psychiatric ward. Okay, she's also been a visiting clinical professor at the University of San Francisco Law School, as well as an adjunct professor of moot court and legal writing at Hastings College of Law. She's published scholarly and opinion articles in Hastings Women's Law Review and the California Lawyer magazine. Ms. McGinnis has served 2 terms on the California Commission on Disabilities Access. She recently was appointed by Governor Jerry Brown to a 3rd term pending Senate confirmation. The Commission's mission is to promote disability access in California through communication and collaboration among the disability and business communities and government here. So hopefully this will help you in your mission here a bit today. She is a vice chair of research of the research committee and a member of the legislative committee. At the invitation of presiding Judge Phyllis Hamilton, Ms. McGinnis sits on the General Order 56 Advisory Committee for the U.S. District Court of Northern District of California. She speaks to a wide variety of audiences about how the ADA, the Fair Housing Act, and other discrimination laws affect them. She's always welcomes opportunity to consult and offer options for improving compliance with the law. Now, as we just go into this here, this has been an area of law that has been under attack, and it still is important. Maybe part of this, as you can go through this, is that our laws in California actually predate the ADA. In fact, a lot of the ADA is based on California law. And I know one of the complaints we hear is that whether or not business owners that are hit with a violation have had proper notice. Maybe, Celia, you can go into how much notice does a business owner need to know to make things accessible. Anyway, with this is a really important subject here. We hope you all learn a lot here. And Celia, thank you so much for speaking to our group.
It's my pleasure. And if I forget to talk about the notice question, please remind me, and I will cover that at the end.
Last thing I will mention, if you have questions, Amy is watching questions on the chat box. Maybe we can go to the next slide real quick here, which should be about continuing education. This is this does get 1 unit of MCLE credit, maybe a little more depending on how much time we spend today. And in order to do that, there For those of you that have the form, what you need to do is include 3 code numbers that will come up during the presentation. Here, for those of you that are not watching live, once again, you can still get credit. What you'll need to do is get the forms here to be able to apply for credit. And if you don't have them, you can get them by emailing Amy, AMY, @gspt.org. And now I'm done, and we'll turn it over to you.
Well, thank you, everybody, for listening in today. I'm very pleased to be able to speak to you about this topic. I have been a litigator my entire career, but I came to disability rights through my personal experience with my daughter, who was born with severe physical disabilities. And I've learned that this is a fascinating area of law and really important that everybody at least understand the basics and have an outline of how the laws work together to provide protections for people with disabilities. So today, we have a lot to cover, and so I am going to scream through some of these slides and maybe even skip over a few of them, but I wanted to include them in case you can go back later and take a look at more detail. Today we're going to cover the ADA and similar laws. As Steve said, there are 3 laws: the California Disabled Persons Act and the UNRU Act and the California Fair Employment and Housing Act, which provide really significant adjunct support and additional rights, more than the ADA is able to provide. And so when we work with these laws, if I speak generally about the ADA, a lot of times I'm actually referring to the entire panoply of statutes that we use to assist people with disabilities to ensure the goal to have equal access to the community. The ADA itself has 5 titles, but I am not going to cover it by title. I am going to instead speak of a few definitions that are pretty much consistent across the statutory scheme. We'll talk about key concepts that apply across the statutory scheme, and then I'll talk about the ADA in terms of the 7 access protections. We'll talk a little bit about service animals specifically, and then we'll speak about legal resources for people with disabilities. All right, leaping in. Now, the first preface I have in the slideshow is about language, and I'm actually not going to talk about it today, but I included it here because sometimes people who are allies with people with disabilities feel uncomfortable and they don't know what kind of language to use. So I included it there if anybody wants to go back and look at that and see what kind of language, generally speaking, the disability community prefers in 2019. But I do want to spend a moment on what I've called another preface. This slide says another preface, the people who made this talk possible. And for those of you who are watching and are sighted, I'm going to say that as I go through and there are photographs or cartoons in the slideshow, I'm going to describe them out loud so that people with visual disabilities can see what's on the slide. If I don't speak a slide out loud, then you can be assured that I have covered everything that is on the slide. So this next slide shows 2 photographs of people with disabilities who are marching for their rights. The first one on the left is a close-up of a woman who's sitting in a wheelchair carrying a sign that says, "Fix the system, not me." And the second photograph is a wider shot. It shows the Capitol in the background, people with disabilities and their allies marching, some in wheelchairs, some walking, and I see some service animals as well. So I just want to say that these are the people that made the laws happen. The ADA became law in 1990, but disability activism goes way back to the 60s, and there was a lot of hard work in the 70s and 80s to lay the groundwork for the ADA. People marched, they held sit-ins, they organized letter writing campaigns, and they generally petitioned their government to ensure that we have the laws that we take for granted today. But I must say, we probably shouldn't take them for granted because the ADA was almost gutted in Congress last year. And it was only saved by a lot of hard work by a lot of people, including people with disabilities who threw themselves on the floor and wouldn't leave until the security had to drag them out of the hearing rooms. And also people like Senator Tammy Duckworth, who is a senator who has a disability. Shout out also to Jim Langevin, the Democrat of Rhode Island, who is the first quadriplegic member of Congress over in the House. And they say they would not be where they are today if it weren't for the Americans with Disabilities Act. So what is the ADA? This next slide states some of Congress's purposes in establishing the ADA. And what I want to emphasize here is that Congress wanted a clear and comprehensive national mandate. It wanted strong, enforceable, consistent standards addressing discrimination against people with disabilities. And it wanted to ensure that the federal government plays a central role in enforcement, which means giving people access to the courts, to ensure that these are not just fancy words on paper, but they're actually implemented so that people with disabilities see the benefits in their day-to-day life. And I will add that the same sorts of policy concerns are at play in California. You will hear me talk about the California Disabled Persons Act, or CDPA, and the Unruh Act, which is our California's omnibus anti-discrimination statute. In promulgating those laws, our legislature said that it considers disability rights a public policy of the highest order. So these are the 7 protections that the ADA and its statutory scheme provides: employment, transportation, education, housing, communication and technology, public accommodations, and government services. You see there's a lot to cover. Some of it I'm going to cover lickety-split. I do welcome questions, and I certainly welcome follow-up from anyone at any time after the webinar ends. But let's start with the basic definition of disability. A disability has 3 components. You're a person with a disability if you have a physical or mental impairment that substantially limits one or more major life activities, or if you have a record of having such an impairment, or if you are regarded as having such an impairment by somebody else, regardless of whether or not you actually do have that condition. The ADA now contains a non-exhaustive list of examples of major life activities that are implicated, which are things as obvious as walking and sitting and standing, and reading and communicating, but also include thinking and analyzing as well. They also, in order to emphasize that impairment isn't just something physical or something that you can see, the ADA also lists major bodily functions like functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, endocrine, and reproductive functions. So if a person has a condition which impairs those functions and thereby affects or substantially affects their ability to do major activities of daily life, then they can be considered a person with a disability. Also crucially important is that when determining whether a person has a disability or not under the law prohibits taking into account the use of mitigating measures, such as medication, assistive technology, or modifications. Even something as simple as my glasses are a modification or an assistive measure that allow me to see better. But when a court is determining whether a person has a disability, they're not allowed to take into account the use of modifying measures. They also say, the ADA also says, that if a person has a condition which is episodic or in remission, they still are considered to be a person with a disability for the purpose of ensuring they're protected by these laws. So, although there are 5 titles under the ADA and 7 protections under the ADA, here are some key concepts that apply across all of those factors. The first is a general non-discrimination provision. There can be no exclusion, denial of participation, no equal or unequal or separate benefits, and no discrimination by contract. An entity cannot vendorize someone else and in that way escape their obligation to provide access. They remain obligated to provide and ensure non-discrimination even for their contractors. The second key concept is there can't be any discrimination in eligibility criteria. So entities are carefully scrutinized to see if they have any criteria or requirements that screen out or tend to screen out people with disabilities. Third, the law requires entities to make policy adjustments if necessary, such as reasonable accommodations or reasonable modifications when necessary to ensure that people with disability have equal access. And finally, these laws mandate communication access, such as equally effective communication or the use of auxiliary aids and services when necessary to assist people with sensory disabilities. Similarly, across all of these protections, there are key defenses that an entity can use if it's accused of discrimination to say, no, either we don't discriminate or we don't have any option but to discriminate. And so here are sort of the four key defenses that are allowed under the statute. The first is, really important, a nexus to disability requirement, which means that a link has to be shown between the disability at issue and the modification or adjustment sought. So if I'm a person in a wheelchair and I only use a wheelchair, for instance, I can't seek remediation of problems with stairs because that's not something that affects my disability, or I can't seek remediation of something that only affects people with sensory disabilities, for instance. And that's to ensure that the people who are seeking to improve the situation have what's known as standing, or they have an actual conflict or an actual problem, not a theoretical one. The second type of defense is referred to as a balancing of interest defense, which you heard the terms undue hardship or undue financial or administrative burden. And the key concept here is that the term undue is important because the law understands and expects that entities will end up perhaps using more resources, whether in time or energy or money, to ensure equal access for people with disabilities. And that's expected. However, there comes a tipping point when the burden becomes undue and then they're excused from compliance with the law. Now the question is, what's undue? And the answer is, it depends, which you'll probably hear me say a lot, but it depends on the facts of each case. The third category of defenses is safety defenses, such as a legitimate safety risk or direct threat. You hear these kinds of defenses raised in jail and prison cases because the law recognizes the need to balance the rights of people with disabilities in those contexts with the legitimate security needs of the jail or prison. You also hear this direct threat concept raised a lot in service animal cases, and we'll talk about it a little bit more in that context. Finally, the last category of defenses refers to compliance with other laws, and that means drug-free workplace laws, federal workplace, or licensure regulations. And essentially, this is an entity saying, well, I would like to not be discriminatory, but if I do what you're asking, I'm going to run afoul of another legal obligation I have, such as a licensure requirement. And my caution when an entity raises this kind of issue is to say, well, what is it about this other law, this licensure regulation, for example, that is forcing you into discriminatory behavior? Maybe we need to go and look at that and seek a modification of that obligation as well. So these defenses literally are the exception rather than the rule to the protections of the ADA, and the burden is on the business or government entity which wants to limit access to establish the facts supporting these defenses. People often express some concerns about the scope of the ADA, who is covered, and so this next slide talks about common concerns that sometimes are raised about the ADA. When it was passed, Congress made probably a moral decision to exclude some conditions from coverage by the ADA. So substance abuse disorders resulting from the use of current illegal drugs cannot make you a person with a disability for the purpose of the ADA. But if a person is an addict and is not currently taking drugs, they do qualify for ADA protections if they have a condition that's disabling that arose because of their use in the past of illegal drugs. Similarly, pedophilia, compulsive gambling, kleptomania, these are not included as disabilities under the ADA. It's also important to know, people sometimes ask, citizenship is not required before a person can be protected by the ADA. The ADA refers to all people without regard to their documentation status. So I labeled this next slide useful provision because it is one of my favorite concepts under the ADA. What we have here is a cartoon in black and white ink of a person sitting in a wheelchair pointing up a set of stairs with a smile on their face as if to say, we have to go up there. And their companion is standing next to them with their hands in their pockets, kind of slumped over, with a look on their face like, yikes, and a big exclamation point above their head, as if to say, oh my gosh, how are we going to do that? This cartoon illustrates the point that people who associate with or have relationships with people who have disabilities also are harmed by discrimination against the disabled person. And so, people who are in relationship with a person with disabilities also have the right to seek protection under the ADA, as long as the companion has suffered a direct harm. So my favorite example of this is a case where a grandfather was taking his granddaughter to watch her brother play football, and the granddaughter had cerebral palsy and used a wheelchair. But there was no accessible path of travel from the parking lot to the football field, so Grandpa had to lift her out of her chair and carry her across the field while someone else brought the chair. And this was uncomfortable for him and unsafe for both of them. So Grandpa sued on behalf of his daughter and himself and said, I'm experiencing direct harms as a result of the failure to provide an accessible path of travel for my granddaughter. And the court agreed and issued an order that an accessible path of travel had to be created. So other situations are hotels or timeshares where there's not accessible features, or the person with a disability is charged more because they have a disability. The inability to go on a vacation or to have your vacation limited harms the loved ones as well as the person with a disability. So this is an effective tool that can be used when the person with a disability is not able to take the lead in advocacy or litigation. Family members can be plaintiffs. All right. When we talk about access, what exactly do we mean? Broadly speaking, access is the right to participate fully in all areas of society, to work, to be housed, and to participate in your community. It's basically the right to do things that able-bodied people do daily over and over without even thinking about it. The right to be unexceptional. And the standard for access is a high bar. It doesn't mean mere usability. It doesn't mean, well, I was able to get there. It means a high degree of convenient accessibility or meaningful access. All right, so now we have the first MCLE code slide, which is 2326, in case you're seeking continuing education credits for this presentation. So now we're going to start talking about the 7 protections, and as I said, I'm going to blaze through a couple of these pretty quickly, just enough to give you an overview. The first is employment, and we have here a picture of some people, looks like an open office plan, sitting around a table and discussing some papers, and underneath the table is the service dog patiently waiting for something to do. Who is covered by the employment obligations of the ADA? Public employers, meaning state and local governments, and many, if not most, private employers. There are some exceptions for small businesses and entities. And in order to be covered under the ADA, the employee must be considered a qualified individual. But that just means that you can do the job, the essential functions of the job, with or without accommodations. So if you can perform your job only if you have voice output software, you're still a qualified individual because you can perform the essential functions if you have a reasonable accommodation of your disability. The ADA employment protections prohibit discriminatory job qualifications and testing. They require reasonable accommodations to be made by an employer, such as physical alterations to a facility, all the way to job restructuring and adjusted hours. The defenses include things like business necessity, we don't have a choice but to behave this way, or again, undue hardship, this is asking too much of us. Be careful because there are some rights that a person with a disability has to function in the office that aren't limited to the essential activities of the job, and they're not really reasonable accommodations, such as the right to inject yourself with insulin and the right to use a service dog in the workplace. Those are not reasonable accommodations. All right, the next category is transportation, and here we have a cartoon in black and white of a person in a wheelchair outside of a bus, and they're pointing at the stairs to say to the bus driver, I can't get in because there are only stairs here. Both the bus driver and the person with a disability are understandably upset about this. So the entities that are obligated to provide equal access to transportation include state and local public transit agencies, paratransit authorities, and Amtrak. Also privately owned businesses, including, they call them over-the-road buses like Greyhound, taxis, and transit station operators. The ADA does not cover air carriers or airlines. There's a special statute for that, which unfortunately provides a lot more limited protection. And again, the standard for access for transportation is readily accessible to and usable by individuals with disabilities. The next factor that we cover is education. And here we have a graphic of some children who look like paper dolls cut out of different colors of tissue paper, and they're holding hands, and two of them are using wheelchairs. Now, education interacts with a couple of other really important statutes: the Individuals with Disabilities Education Act, or IDEA, and the Rehabilitation Act of 1973, Section 504 of that bill. We don't have the time to go into those today, and this webinar series has a separate session on IDEA and those related statutes, which I've seen presented by a person at DREDF. It's excellent. I highly recommend it. But today we're just going to do a short overview to give you a context for the relationship between the Americans with Disabilities Act and IDEA. But for those of you who haven't any experience with education law for people with special needs, I'll just tell you first, the IDEA is a federal special education law which guarantees children with disabilities that affect their learning a free, appropriate public education in the least restrictive environment appropriate to the needs of the child. Well, how do the ADA and the IDEA interact? Here's a handy chart that shows you. The ADA prohibits discrimination on the basis of disability in schools, and in all places, but also in schools. The IDEA guarantees a free and appropriate public education, also you might hear the term FAPE, when your disability affects your education. The ADA covers physical access even when IDEA does not apply. The ADA is not a funding source, but IDEA does provide funding. The ADA covers all persons with disabilities, and the IDEA only covers students aged 3 to 21. The ADA applies to public and non-sectarian private schools, and the IDEA funds public education. The ADA does not have any procedural protections for education per se, and the IDEA does have procedural protections to determine and guarantee what is FAPE. So the most important use of the ADA in this context is that it covers the ability to physically access the school facilities even when they're not directly related, arguably, to the child's education. So it guarantees accessible restrooms, auditoriums, lunchrooms, classrooms, etc., etc. I had a case in Oakland, which I brought against the Oakland Unified School District because of an elementary school, which was, of course, focused for children with physical disabilities, but it was horribly inaccessible. And I brought that case on behalf of a social worker who also uses a wheelchair, not on behalf of a child, but he needed equal access to the school in order to serve the children in his caseload. We settled the case with OUSD to get new safe wheelchair ramps, a safe space for bus drop-off, accessible restrooms, and my favorite part, which is a more accessible playground for those students. This was a really important case to me because it allows children with disabilities to act independently according to their true age and abilities, rather than infantilizing them because the space around them is not set up for them to function. It's critically important that students get equal access because it allows them to turn into and grow into the independent adults with disabilities that we want and expect them to be. All right, blazing on toward housing. And this is a black and white graphic that shows a residence with an enormous wooden ramp coming down from it, leading to a parking pad that's striped for van access, and there's a wheelchair van with its ramp deployed, and two people coming down the ramp, one in a chair and one walking. So there are four main laws that implicate the rights to housing. In addition to the ADA, there's the Fair Housing Act, which is a federal law, the Fair Employment and Housing Act, which is a California law, and also the UNRU Act. Together, they cover pretty much all residential housing that you can think of. That provided by state and local governments, provided by most landlords, and it covers temporary housing as well as residences. So it can include hotels, it can include homeless shelters, and it include domestic violence shelters as well. So housing access means that a couple of things. First, there's the physical requirements of access. Residential multifamily buildings built after 1986 must have accessible units or the ability to have accessible features put into them. So they have widened doorways, they have strengthened walls in the bathrooms so grab bars can go in. In addition, there are what I refer to as policy protections, which means that landlords must make reasonable accommodations for a tenant who has a disability that affects his or her ability to get full use and enjoyment of their housing. Reasonable accommodations can either be changes in policies and practices, like allowing a person with a disability to have a co-signatory on a lease to guarantee their income, or it can be modification of the physical premises. Those are technically referred to as reasonable modifications, but oftentimes they're just all lumped together and called reasonable accommodations. And the main defense in these kinds of cases is, again, undue hardship. You're asking too much of me, says the landlord. All right, the next kind of protection is communication technology. And this has a graphic that says accessibility online with a little picture of the universal blue wheelchair symbol and a computer mouse. This is a very hot area of the ADA, so I want to make sure that, and it's also extremely intricate, so I'm going to just touch on the main points, and I'm happy to come back and talk about details later or at another time. So the ADA and associated laws guarantee access to government services like translators or interpreters and accessible government websites. It also mandates the telephone relay system and TDD. It requires that communication access be given 24/7 and at no greater cost than to the general public. And it affects the internet, which is where you hear about these cases today. Website design needs to have built-in accessible features so that people with visual disabilities can hear what's on the page, so anybody can easily find out what is being said on the website, even if they have sensory disabilities. Posted documents have to be accessible, And videos and other multimedia need to include audio descriptions, like I've been doing of the photos today, and captioning. This is really simple because access in the world depends upon communication, whether it's in person, government meetings, entertainment venues, or the internet. So the unfortunate part is that this hasn't had as much attention as cases about ramps and restrooms. People with disabilities who are visual disabilities or who are deaf or hard of hearing have much more difficulty participating in our society today. But remember, you have the right to transcription, to ASL, to captioning in movie theaters and at plays. It's technically very simple, actually, in most cases, and it should just be available upon request. All right, now we have reached the second MCLE code, which is 3875 for those of you playing along at home. And we are going to move into the topic that most people think about when they think about the ADA, which is public accommodations. And here we have a cartoon in black and white of a very strong person carrying a person and their wheelchair up a flight of stairs. And the person in the wheelchair looks scared to death. They have their teeth bared, their hair is standing on end, they have those little stress wiggles coming out the top of their head, and they're understandably very frightened for their safety. Title III of the ADA is the section that most people think about when they think about access. It covers privately operated public accommodations, which means businesses and nonprofit organizations that are open to the public. It includes owners, operators, lessors, and lessees, which means that if a business is operated by one entity and it works in a building that's owned by a landlord, both of those entities together are jointly and severally liable, which is a legal term for they're both fully obligated to provide access regardless of what the other is doing. So they both have the same responsibilities. There are a couple of exceptions to that, but for the most part, it's a very strong principle that says you cannot, as a landlord, contract away your liability and make your tenant responsible. Similarly, as a tenant, you cannot just assume that your landlord has made the building accessible and not worry about it yourself. Now, leases can transfer the responsibility from the landlord to the tenant or vice versa, but that responsibility is only as affects the two of you. There's nothing in a lease that can free an entity of its obligation under the ADA. Religious entities and private clubs are excluded under federal law. Religious entities are not excluded under state law. But the question of what is a private club is a really interesting one, because a lot of clubs that label themselves private wouldn't be considered so under the ADA. For instance, if it's a private club but will accept membership from anyone who pays the dues, that's not a private club for the purposes of the ADA. So there's a multifactorial test to determine whether a club is truly private and inward-looking. But, for example, your local swim club is not a private club if anyone can join and participate. If it's only open to members of the HOA, then it might be a private club because its membership is restricted, but then remember that the fair housing laws are going to apply. So there's really no escape from the obligation to provide equal access for a lot of private clubs. As with the other areas of protection under the ADA, there are two kinds of barriers that the ADA discusses. The first is architectural barriers, and the second is policy barriers. And we will discuss both of those. I think we have covered this one, yes. So let's talk about architectural access. Architectural access applies to the physical plant, and it also includes tactile signage and signals that are relevant to people with sensory disabilities. The important takeaway here is that there are no buildings that are public accommodations that are free from some level of ADA obligation. In other words, There's no such thing as grandfathering out. You cannot say my building is so old that the ADA does not apply to it. There are, however, differing levels of obligation depending on the construction and alteration history of the building at issue. So if we look first at brand new construction means anything built after 1992 for the ADA to apply, or under state law, anything built before 1968 if government funding was involved, or 1970 for all public accommodation buildings, regardless if they were built with private or public funding. So that means that even if even if a building is considered a pre-existing building under the ADA, under state law it may be considered new construction. And 1970 is a pretty long time ago by now, so I would say that it's certain that many buildings that we use every day are considered new construction for purposes of interpreting the law. If the building does predate those statutes, but it has been altered in some way since, then it's called an alteration or construction alteration, and it also is subject to the heightened standard. And the heightened standard means that the building had to comply with whatever construction regulations were in place for disabled access at the time the facility was constructed. And so when the laws were first passed, there were fewer regulations. Now there are more regulations, but the point is that whatever regulations were in place at the time the building was constructed or altered, they had to comply with the construction at that time. And an alteration isn't just throwing up a new wing on the building. An alteration is anything that affects the usability of the building. So changing a part of a building from one function to another function, for instance, is considered an alteration. Now, for buildings that pre-exist the federal 1992 law or the state 1968-1970 law and have had no work done on them, they are not free from obligations for access. Under federal law, there is a standard called readily achievable, and the ADA says that for pre-existing buildings that have never been altered, they still must remove whatever barriers to access exist that are readily achievable to remove. And what does that mean? Well, the definition of readily achievable doesn't really help a lot. It's still pretty vague. It's easily performed without too much difficulty and expense. And what is too much and what is too hard, that's left for interpretation on a case-by-case basis. But there are a lot of factors that are built into the regulations supporting the ADA which give us a little bit more information about how readily achievable will be interpreted in any given building. But it's important to know that the Department of Justice promulgated regulations under the ADA that has a list of presumptively readily achievable barrier removal tasks. And that includes widening doorways and installing ramps, and of course grab bars in restrooms. So it may be that the barrier that needs to be removed is presumptively readily achievable, and so you need to review the regulations to check and see. All right, and let's address the case if the building is very old, has never been altered, and removing the barriers would not be readily achievable because they're too difficult or too expensive. Does that free the owner or operator of such a public accommodation from any ADA obligations? It absolutely does not. Because even if a barrier is not readily achievable to remove, then the business has to provide alternate methods of creating access and provide basically equivalent facilitation so the person with a disability can still use the goods and services. So if we think back to that cartoon of the strong man carrying a person in a wheelchair up a stair, I actually had a case like that where a young man loved this particular burrito joint in San Jose and used to go there all the time, but then he had a car accident. He became paraplegic. And when he was going through his rehab, his brother-in-law said to him, "Come on, let's go back to the burrito joint for old time's sake," to kind of try and move him back into the world. Well, they drove up to the burrito joint and realized something that they'd never had to pay attention to before. The only way in was by a flight of stairs. So my client didn't go in, went home, and he was devastated. And he was thinking to himself, sitting in his room, my life is over. I'm paraplegic. Nobody wants me. I'm not ever going to be part of society. Fortunately, he picked himself up and he called us. And when the case went to trial, we had his testimony, but in addition, we had the testimony of another young man who's a paraplegic. And the way he used to get around the stairs, so to speak, is he would get out of his wheelchair, wrap his arms around his cousin's neck, and his cousin would literally carry him up the stairs, clinging to his back, and somebody else would wrestle the wheelchair up the stairs as well. Now, that takes a lot of guts and a lot of upper arm strength, and good for that young man to try that approach. But the court ruled at the end of that trial that no, they had to provide a wheelchair lift for people to get in. But the court gave the business 6 months to install that lift, and it said, in the meantime, before you have actual physical access, you have to provide your goods and services via alternative methods. So it ordered them to put a menu down at the street with a buzzer so that people could call in and place an order from the street, and it said, as a matter of policy, you employees of the business have to come and bring those burritos out to the person standing on the street. And so that was an excellent example of an order of alternative methods to ensure equal access, or as close to equal access as they could get. All right. Policy changes are sometimes required, as we discussed, the method of providing your services. But it's important to think about the fact that some policies are just exclusionary per se. We don't allow people with disabilities. And some policies are called disparate impact policies, which means they appear to be facially neutral, but they actually work a hardship in practice upon disabled persons and not upon able-bodied persons. So I have an example of that. We had a lawsuit against a local private tennis club, and the tennis club often sponsored tournaments where members of the general public could come, and they had numerous courts, obviously, but some of the courts were not accessible, and they couldn't be made accessible because just the geography of the court and the hills wouldn't allow it. So what we had is, to effect access, we had them do a policy change, so that they had to change the rules in their process, so to make sure that the semifinals and the finals of each tournament were held on the courts that were actually accessible. So their policy of holding their finals on a given court that wasn't accessible was facially neutral, but it had a disparate impact upon people with disabilities. All right, now this is the final of the 7 protections that are afforded by the ADA, and it's equal access to government programs, services, and activities. And this is a black and white cartoon of the U.S. Senate building, and the stairs leading up to the building have been exaggerated to be wider and taller. There's 6 flights, and at one point the stairs do a loop-de-loop to emphasize the lack of access. There's a person who uses a wheelchair sitting at the bottom of the stairs next to a sign that says, "Disability Treaty Entrance This Way," which was a joke made because in 2011 or 12, when the Senate was considering whether the U.S. should be a signatory to an international disability rights treaty, the Senate building itself was not accessible. The federal government exempted itself from the ADA, although the legislative branch made itself subject to the ADA by a separate law in 1995, but a lot of functions are not of federal government, are not covered by the ADA. They are, of course, covered by the Rehab Act of 1973, which is a similar set of standards, but it's one of those little quirks where the federal government isn't necessarily subject to the same laws that state and local governments are. So Title II of the ADA covers all activities of state and local government, and it says no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or denied the benefits of the services, programs, and activities of a public entity, or be subjected to discrimination by such entity. So it's a little strange. The term public accommodation under the ADA means private businesses, and the term public entity under the ADA means a government. But the bottom line is that a service, program, or activity of government means basically everything the government does. Everything the state and local government does is subject to the obligations of the ADA. And that is both, again, physical access and policy access. So how does it work for government buildings? The same sort of new construction, altered building standard applies, but Congress intended that state and local governments have actually greater obligations than private entities do, because it recognized that the ability to approach and use the services of governments is a fundamental democratic right. So for buildings that have not changed since before the advent of the ADA in 1992, Congress came up with a concept called programmatic access. So that means that if a government service or activity is provided in a building that is not accessible to people with disabilities, the government has a choice. It can either remove the barriers to access, or it can move those functions to an accessible facility, or it can duplicate those services, as long as they're really duplicated, and provide them in two locations, one inaccessible and one accessible to people with disabilities. That's a much broader standard than saying, well, to private entities, well, you only have to do what's readily achievable. It says you have to provide exactly the same program, services, and activities. You have the choice to figure out how you're going to do it, but you better do it. Remember, however, that in California, government buildings that were built before 1992 are still going to be subject to the construction and alteration regulations applying to buildings going back to 1968. So a government building that's in California may be subject to both the ADA and construction obligations under California law. So what kinds of cases do we run into here? Well, not surprisingly, courthouse access cases. A lot of community colleges have issues with both physical access problems and policies that interfere with equal access for people with disabilities, and jails and prisons, because both prisoners and visitors to the jail have the right to equal access. In that regard, I had a case against the Monterey County Sheriff, because they have what was called the Sheriff's Work Alternative Program, which means that people who are convicted of minor offenses, instead of serving their jail term, can be released and do community service to make up their time instead. But the Monterey County Sheriff did not accept any people with physical disabilities into this program. So my client, who used a cane, had to serve 30 days in jail because of her disability, instead of being like an able-bodied person released to work and be at home with their family while they worked off their jail time. So we had to sue them, and they changed that policy. But that's the kind of thing that can affect a lot of people. All right. Now let's talk about service animals. There are actually 5 different terms that are applied to animals that work with people with disability. Service animals are, by definition, an animal specifically trained to perform a specific task for a specific individual. A therapy animal is trained in therapy, as the term implies, but it's usually used in a therapeutic milieu, like a mental health clinic or a hospital, and it is not assigned to any single person. Emotional support animals is a term used by housing and urban development to indicate that the animal provides a very private function for a person with a mental or emotional disability. By their very nature, their presence is what is assistive, their comfort, and so they can relieve depression and anxiety or reduce stress levels. The term comfort animal is sometimes used interchangeably, but it's not really found in the law. And then HUD uses the term assistance animal to distinguish itself from the ADA, because an assistive animal can be an emotional support animal or comfort animal, but is not specifically trained to perform a specific task. Those terms get people confused, but this is a basic way to show the distinctions. Service animals, under the ADA, there's only two kinds of animals that can be service animals: dogs and miniature horses. If you have a miniature horse service animal, I would like to meet it because I have never met one, but we see service animal problems all the time. Service animals are entitled to go anywhere in a public accommodation or a government facility that a person with a disability can go, with a few clearly stated exceptions, and that means that they can't go where immunocompromised people are, and they can't go into sterile environments like operating theaters. It's sort of common sense. But otherwise, they can go anywhere a disabled person goes, their handler goes, so long as that animal does not pose a direct threat. The presence of the animal doesn't pose a direct threat either to the person with a disability or to the general public. And direct threat does not mean we're afraid of animals, we're worried about what might happen, we're worried that someone might object. Direct threat means that you have to analyze this animal in front of you to see if the direct threat is present and imminent. And in addition, you also have to ascertain, is there any way of mitigating or ameliorating this threat so that the person can have their service dog? It's only if you find that the animal is both a direct threat and there's no way around it, there's no mitigating measures, only then can a service dog be excluded from a facility. California also explicitly requires access for service dogs in training. All right. And under state law, this direct threat is not really stated explicitly, but it does say that service animals don't need to be allowed in zoos and animal parks. All right. So here's some examples. Hospitals, anywhere the patient goes, except as I've described, buses and grocery stores, restaurants, the whole shebang. People have concerns about service dogs, and they say, well, why isn't licensure or professional training required? And the answer to that is because that's expensive, and people with disabilities often have very limited means. And there's no reason a service dog can't be a legitimate service dog if you train it yourself at home. We certainly train dogs at home all the time. You don't need a professional handler necessarily to train someone to be a service dog, as long as you do a good job and are a good citizen when you go about doing it. People ask, well, what can I ask to make sure that a dog is really a service dog? There's two questions. Is the dog a service animal required because of a disability? Just memorize that phrase. Is the dog a service animal required because of a disability? And what work or task has the dog been trained to perform? Those two are sufficient, and that's all you can ask. You can't ask what's your disability, and you can't make the dog perform the task. Say, show me the task. That's not allowed. And that's because there are some service dogs, like diabetic dogs, and dogs who serve people with epilepsy. They only do their job, their task, in case of an emergency. You cannot ask for medical records or documentation. You can't ask for licensure. You can't ask for vet records. If the dog presents to you and it looks clean and well groomed, then you can presume that it is not a threat to the people around it. What about people who are fearful or have allergies? What about dog diseases? Well, it's just a matter of working with the dog and the other people to ensure that there's some division between anyone who's afraid of a dog can just avoid the situation, basically. Anyone who has an allergy, it makes your nose itch, you can also avoid the dog. If a person has an allergy that rises to the level of being a threat to their life or otherwise affects their own major life activities, then you're presented with a situation where you have two people with disabilities and both of them need to be accommodated. There's a document from one government agency I remember that was talking about service dogs in the context of dialysis clinics and how do you separate, what do you do about the fact that the other people with dialysis may not want to be with a service dog. And the answer came back, close the door. I mean, it's really very simple. You don't exclude the dog, you find a way of working with the situation. And in fact, regarding diseases, the CDC did a study about bacteria that come into hospitals that obviously came from dogs, and they found that the problem was that nurses were bringing the bacteria into the hospital from their own pets at home. It wasn't a service dog problem, it was a hand washing problem. So with a little bit of good faith, a lot of problems can be avoided. All right. Emotional support animals are limited to housing. It includes dorms, assisted living facilities. They're not limited to dogs. They can be any kind of animal that actually provides comfort. And because I'm running out of time, I want to just say if you have more questions about emotional support animals in housing, I'm happy to answer those. We handle those cases all the time. Do I have to sue under the ADA or under state law? No, you don't have to sue. There are ways of filing complaints with government agencies if you experience discrimination. I will say that the governments get a lot of them. They often try and get folks to mediate, which means work it out with the facilitation of a government employee. That can work very well in some instances. In some instances, it's a long and slow process. If a person files a complaint and they don't get the outcome that they think they should get, they still have the right to sue. But remember, there are limitations on how long you have to file a lawsuit. And so if a person experiences discrimination, they're considering filing a lawsuit, they should not wait. They should go ahead and contact an attorney so they don't lose the right to bring their claim. All right, this is probably the single most important slide in this entire presentation for people who are watching this who are lawyers. Unfortunately, in an effort to combat what is seen by the legislature as a problem of lawyers sending abusive demand letters to businesses demanding money, and the perception that businesses are giving them money and to make the abusive lawyers go away, the legislature passed a couple of provisions that put very strict requirements on what a lawyer can say and do when they send a demand letter or file a complaint that relates to a construction, we call it crack. Construction-related accessibility claim. All right, so this very specific subset of physical access barriers, if you're going to send a lawyer or make a verbal request, either from the lawyer or at the direction of the lawyer by a layperson regarding these construction-related accessibility claims, whether or not you ever intend to file a lawsuit, whether or not a lawsuit is ever filed, there are some things you can't do, you cannot do, and some things you must do. And I strongly urge you to look at these two statutes, Civil Code Section 55.3 and 55.31. But even more importantly, if you're in the position of thinking of sending a demand letter to a public accommodation or government entity for a physical access barrier, just call my law firm. We have models. We are very careful about doing this, and we will help you out, because the penalty, if you don't, is that you can be sanctioned by the state bar. You have to send a copy of these demand letters to the state bar and to the California Commission on Disability Access. You have to send copies of all your physical access barrier complaints to the CCDA as well. And I have actually had the bar call me twice in the last 3 months to say, prove to me that you actually did this. Of course we did it, and we did it right. But it's really, I think, an impingement upon the First Amendment rights of people with disabilities and their advocates. Someone will challenge it someday, I'm sure. Here is the third MCLE code, 3782. So why would you sue under the ADA and state laws? There are really good reasons to do that, because, and this law was set up to ensure certainty, permanence of change, and community benefit. The goal here is to get an injunction to change the behavior. That's an order from the court to force the offending entity to make the change that's necessary to provide full and equal access, whether that's change to the building or a policy change. In addition, people have the right to receive damages under state law, and in some instances, if they're damaged by a government entity. The violation of your civil rights is a harm in and of itself, and the California legislature has recognized that. In addition, it's expensive to hire a lawyer to fight, especially against a huge public corporation or the government. And so in this statutory scheme, as well as the Clean Air Act and the Clean Water Act, the government has provided that if the plaintiff in one of these cases prevails, then the defendant must pay for their attorney's fees and costs and litigation expenses of litigating to ensure compliance with the law. This shifts the burden of compliance and the cost away from the person with the disability and onto the offender. It's actually sort of a small government idea. Instead of having an enormous bureaucracy, we'll let the market take care of this, and I think it's been effective. All right, the next slide is about the California Commission on Disability Access that I sit on. I urge all people to go and take a look at their website. It has some interesting information, especially to help businesses comply with the ADA requirements. And the next slide has some links to good resources if you're looking for more information on these issues. So that is it for me. I hope there are questions, and I look forward to hearing them.
Great. And let's see. I know Amy's monitoring this, and we're actually looking for questions here. Let's go back to this. I know a big argument that is heard over and over and over again from business owners is that they weren't given proper notice here, and that's an ongoing problem. I know when I was a law clerk at Dredif, we were told that the reason that the laws were set up the way they are is that that the folks who wrote this knew that the Attorney General was not going to enforce this, and the whole concept was that by having a private right of bringing a suit, that this is how it was going to be enforced. How much notice? Well, how long have these laws been on the books, and what do you think a reasonable period of notice might be?
Well, so here are the facts. All of these laws had notice built into them. So the ADA passed in 1990, but the physical access requirements, the barrier removal provisions, didn't go into effect until 1992 to give businesses 2 years to get up to speed and remove the barriers without any liability. In addition, we've had these laws in California, like I said, going back to 1968, 1970. I don't know if there's any business out there that doesn't know what the ADA is. And the problem is, I think that there are a lot of businesses who are acting in good faith, but they may have a lot of fear, and they think, well, I'll bury my head in the sand and I won't think about it until I actually get sued, because what are the odds of that happening? The problem is that just like you have an obligation to go and make sure that you comply with the fire code, you have an obligation to make sure you comply with the ADA. And if you had a fire and your sprinklers weren't working, then you would be liable for the harms that came out of that. And it's the same situation here. So what is a reasonable notice? Everybody's on notice already. And I can't think of any other civil right where the concept is that a person who's discriminated against has to go and tell the offender, you discriminated against me, now you're on notice not to do it again. If you try and translate that concept to gender discrimination or race discrimination, it immediately becomes obvious that it's ludicrous. Businesses know they have an obligation to comply with all the laws that apply to their businesses, and that includes the ADA. So,
yeah,
that's my approach to it. And I have represented defendants myself. I have been in lots of mediation over the course of my career with defendants, small businesses and large businesses, and I often find that the problem can come down to a lack of communication between the building owner and the tenant. So I really urge people, whether you're the owner or the landlord or the tenant, go back and look at your lease and see if it complies with the law. There's a requirement since 2015 that commercial leases have provisions in them that say whether the building has been assessed for disability access, and allows the tenant to take a look at that. And it is supposed to encourage that conversation, but not all commercial leases have caught up to that yet.
Okay, so I know you went through the presentation and you covered a little bit about when you might want to bring a lawsuit, when you might not, or that kind of thing. So I know there's some entities like DREDF and the DRA and all of that. When might you want to bring a private lawsuit, and when might you want to reach out to something like DREDF or the DRA? Can you distinguish between the two?
Sure. Well, there are nonprofit organizations that specialize in, or have as one of their services what's called impact litigation, where they specialize in doing class action lawsuits on behalf of very large groups of people. For instance, disability rights advocates just had a roaring success with making sure that the New York taxi system was accessible, and it tackled the entire system on behalf of all people with disabilities in the city of New York. That can be an effective way of making change, and if you're aware of something that is a huge structural problem across an industry, or especially with regard to one defendant or one government entity, that's a way that you can go. The difference between a class action and a one-person plaintiff lawsuit is really not a huge difference under the ADA, because a plaintiff under the ADA has a right to seek an injunction to force an entity to change a court order. You don't need to file a class action suit in order to get change for the person who's been discriminated against and all the people that come after them. So one person can actually effectuate enormous change. You don't have to always group together. Sometimes it's a good idea, and I've been involved in class action lawsuits, but a lot of times I see that I can get the change that's necessary faster and more simply.
Great. So anyway, well, that actually covers most of what we did today. I know with this, I just want to mention, as a disability advocate, I think there's two things I want to mention. One is that if we have these laws on the books, but we don't enforce them, what's the point, right? And I know right now that the business industry and some have been pretty hard on the ADA and the access attorneys here, and you've gone through some of the different requirements now, the hoops that they've added with this. But even still, if we don't enforce these rules, what's the point? So keep that in mind. And I know when I was doing this work, we would get comments all the time. Well, we never had a person with a disability come and use our facilities before, and go, maybe it's the steps here. And so, it's one of those things that's really important here. The other thing is, for those of us that are advocates, I have to tell you that this whole process of once again, what would be a good term, beating up on the access attorney. This is one of those things that we as advocates need to think about. And when these things come up, we need to look at supports. Go back to this, that, this was set up in California. And I know there may be some differences with the ADA, but the concept was that we needed a private right of action in order to make our public areas accessible. And so once again, we need to support the ADA attorneys and that kind of thing as far as that's concerned, because this is kind of core to moving to the community and having things accessible, as well as making sure that services are available as well too.
In California, we have had anti-discrimination laws that since the late 50s, since the Unruh Act. And they protect people of different nationalities, people of different races. They protect women. They protect religious members of religious groups. And the disability community is a group that's entitled to the same protections. Disability rights are civil rights, and so they should have the same rights of remedy as of people of other traditionally oppressed groups have.
Well, I just want to say as we close this out, and DJ, maybe you could put up Amy's email address again here. I would say two things here, and then I will give you the last word. First off, thank you so much for sharing your knowledge with us. And I will tell you that Celia has been my go-to person when it comes down to protecting a person with disabilities' rights to access and other things. So thank you so much for what you do here, and others that do the same thing. For those of you that are watching this for credit, if you don't have the forms, you can get them by emailing amy@gspt.org. Here, which you can see is once again on the video, and ask her to not only send you the forms but list you for future programs. Here, with that, Celia, you get the last word, and then we will close it out for the day.
Thank you. I mean, we support each other, and this work makes the community more accessible for everybody that comes after us, and that's why I love doing it.
Okay. With that, DJ, thanks a lot, and happy advocating.
Thank you.